Welcome to Spectrum, a daily public affairs presentation of WCSM. And now, here's Spectrum, the talk of Mercer.
And we thank you so much for joining us for Spectrum today. I am your host, Kevin Sandler, delighted to welcome Celina Law Director George Moore to the program. And Mr. Moore, good to see you again. Thank you so much.
Thank you for having me. It's always wonderful to be here.
I wanted to talk with you, not too much new in terms of city business. Obviously, there was not a meeting this past week. There wasn't any legislation. I understand the council members were off kind of attending an educational seminar pertaining to utilities and some other things. The budget's done. We've had the State of the City address. So that seemed like a pretty good time to not have a meeting and let you all concentrate on other things. And we consistently like to remind people you're the city's law director, so yes, you're the guy at the council meeting that reads the ordinances out loud, advises the council meeting on the proper actions they can take to stay within the law. And there's the other half of your job, which is where you are the prosecutor for misdemeanors in Mercer County, along with what we call minor misdemeanors, commonly referred to as citations.
Correct.
And so, for that alone, you have a most interesting job with difficult decisions to make at times.
Every decision is taken very seriously. Some are easier to make than others, But with our court cases that we have, we always try to look in every single one of the files. Large cities have what they call specialty dockets. And sometimes it might be, if it's like a drug type of issue, they might send it to the drug court docket, or various other things like that. And I think the reason they do that is because their dockets are generally so overloaded that nobody has a chance to look into any of the cases, really. And so they kind of, triage those, if you will, to give them what I describe as the time and attention that we try to give every single one of the cases that we have up at our court. We handle everything from speeding tickets, parking tickets, like you said, kind of the minor misdemeanor, the citations. The most serious things that we handle are first-degree misdemeanors, and that can be operating a vehicle under the influence, that could be an assault, that could be a domestic violence. There's other charges as well, resisting arrest, that's a lesser degree than that, and pretty much any misdemeanor that's here in Mercer County, we see that up at Celina Municipal Court.
I would only add to that, too, so people understand the scope of a first-degree misdemeanor. There are times you go to trial. You and their defense attorney state your case to a jury, right? I mean, just like any other, court case that we might hear about, that sometimes the defendant does not want to plead guilty. You and their attorney did not come to an agreement of what's acceptable to both sides. And so at that point, you don't have that option. It's now in the hands of a jury, and you have had trials over the years, quite a few, right?
Yes. Any defendant is free to plead not guilty and maintain their plea, and they can take the matter to trial. If there's a possibility of jail being imposed on the charge, then that person, a couple things. One, they're entitled to court-appointed counsel because of that, if they qualify financially. And also, they are entitled to a trial by jury. So your minor misdemeanor speeding ticket, you can't get an appointed attorney, and you can't get a jury trial on that. But, anything that's a fourth-degree misdemeanor, which is the lowest classified level of a misdemeanor. And so that's like a trespass. The most you could get out of something like that would be up to 30 days in jail and or a $250 fine. And, we take a look at every case that we get, and I'm not saying that's the maximum penalty that's imposed upon everybody for a first, but that is the maximum potential penalty that they could get. But it goes all the way up to a first-degree misdemeanor. And like I said, that's like operating a vehicle under the influence, or domestic violence, or assault. Things, those are the ones people are most familiar with. That carries a maximum potential penalty of up to 180 days in jail and or a fine of $1,000.
All right, and also a couple things to, to keep in mind, with that too is one of the things you said, that they have the right to plead not guilty to maintain their innocence. One thing that I personally take very seriously, I know you do too, up until they make a plea or they are convicted, they are innocent. I've always said I wasn't there, I wouldn't know. In many cases, even with all evidence you had, right? I'm sure there's a moment where you say, I wasn't there, I wouldn't know, and keep that presumption of innocence, right?
It's the state's burden to prove each and every element of the crime charged and to prove that beyond a reasonable doubt. Now, I always explain to juries, it's not beyond any doubt. It's beyond a reasonable doubt. Anybody could plant any seed of doubt, I suppose, but is it reasonable? How's your day going to end? Do you think the world will get hit by an asteroid? That's probably not a reasonable assumption for that, But it's the state's burden to prove the defendant has the constitutional right to remain silent. And if you've ever seen an episode of Cops, that's, you have the right to remain silent. Everybody's so familiar with those rights, but that is an absolute right that carries through to trial. There are other systems of justice where the defendant they can be called to the stand and forced to provide testimony. And that sounds kind of strange even to say, because this is, I guess our founding fathers decided this is the way that our system should be here. And I've worked as a defense attorney before. I've done this law director job. This is my 15th year doing the law director job. I started after doing 4 years of some criminal defense and some other things. But the defendant has the right to remain silent and to be tried by a jury of their peers.
And another thing too, I think whether it's you or I or the audience, we could argue for a long time about our vision of what we want America to be. That opens some doors, right? But we probably can all agree on what we don't want America to be. We would never want to be a place where somebody's presumed to be guilty. Even though sometimes we look at something and say, oh, they did it. We might read a news story and say, oh, I'm sure they probably did it. In the back of our mind, we certainly respect they have to have been convicted.
Can meet all the elements of that particular crime. Casey Anthony's famous case, is famous for many people could not believe that she was found not guilty. And I say, well, she was found not guilty of what the prosecutor had charged her with, because in a nutshell, all the prosecutor needed to do was, basically draw a walk in the game, but instead decided to swing for a grand slam, and they just, they charged the highest, and they couldn't meet the elements there. And so, the defense attorney's job in that scenario, you're holding the state to its burden. And you will hear them tell the jury in the opening, the state, will not be able to meet this burden. And in the closing, they will argue that we did not. Of course, the state brings the case. It's the state's burden. Like, the judge in a case is like a baseball umpire. They're calling balls and strikes, safe or out. The prosecutor is like the manager of the baseball team. It's my case. It's my team, if you will. I decide who's going to be in the lineup, if you will. Like, what witnesses do I need to prove whatever I need to prove here beyond a reasonable doubt? And usually it's a victim and or witness or witnesses. Virtually all of them, report it to law enforcement at some point. And so then I have that law enforcement officer as usually as my state's representative in the trial, because quite often they're not the officer's not there to see whatever the incident was, but they get called after the fact and do their follow-up investigation, and so they can't testify to what happened. I have to have those people there to testify to that, and then the officer comes in and says what they did as part of their job.
All right, talking to George Moore, Law Director for Celina. Another thing, too, sometimes we're always not clear on what the law is, and perhaps sometimes a person cools down right after reporting a crime, and they might say, on second thought, I really want this to go away. Let's just drop everything. I don't know if in some cases you can do that. I know there are some cases where you absolutely can't do that per state law, I understand.
There are some cases where, some criminal charges where the charged person has to see a judge first. And that can be anything from passing a stopped school bus. Like, you can't just go and, post the bond in lieu of, you have to actually go see the judge for that. And, domestic violence is a similar one that has a similar, there's some, I guess, requirements that go along with that. For example, one, if a person is arrested for that, they are going to sit in jail until they see a judge. And that is because that judge, and this is not just a local thing, it's state, probably national as well, but they want to make sure that defendant has a bit of a cooling off period, like you said, because I think it was inspired by some tragic situation where they'd, released the violent suspect, and he went right back to the victim and, committed further crimes, whatever it was. And so that's, there's some mandatory things. Some people will, they'll call law enforcement, or even on the scene. Sometimes they don't want anything done. And I will say sometimes the law allows more officer discretion than at other times, and again, some, like, if they believe it's, so domestic violence is basically like an assault plus a family member as an additional element to it, and the officers generally have more discretion, if you will, if there's not that family element that's also met. And so pretty much once that's met, if they determine if there's one or more primary physical aggressors, because you can have a couple, we'll say, going at it, quote unquote, and they could both be primary physical aggressors. One, A could attack B, B could kind of, reel back, and now the situation's been calmed down, now B runs and attacks A. B might say self-defense, but you have to look at the facts of that. Like, was it like contemporaneous? Was it a moment later? Was it 5 minutes later? And so once they determine then that there's a primary physical aggressor or more, they are going to arrest that person, even if the person who is the alleged victim and is the one who called and even said, I want them arrested, and then said, oh, well, I changed my mind. If the officers believe they've got enough for the primary physical aggressor, they will arrest, and no matter what anybody asks, that person will not be released until a judge authorizes it. And, the judge will look at the situation and see, they didn't just get here, like something led to people coming into the court system, and so they'll try to see, like, does this suspect defendant, do they have another place that they can go, because we probably need to keep this alleged victim here safe, does the defendant have a drug issue, do they have an alcohol issue, why are we here, I guess, we can only do so much based on what the law allows, for us to do. We can't just like order people into, to a mental hospital if they're having mental issues that are causing them to commit criminal behavior. Can't order that, but we can say that if you seek, treatment for this, maybe we can delay your your case here for a few months, you know, and reevaluate it at that point. And like, I'm always interested in like, what's the best way to, I guess, further the interests of justice, because it's not what the victim wants, it's not what the defendant wants, or, you know, it's like you gotta, what is justice in the case, you know, and that's why we try to look into all these cases here, because, you know, sometimes justice, I guess, on the state's end looks different than how somebody else might see it. And everybody's entitled to their opinion, of course.
Yes, that they are. George, we're going to take a break. We'll talk more about this. We're not going to lose our place either. It's a great line of communication as we continue on Spectrum. Is here, Celina's law director, and so we've been talking about, you know, when you're considering, you know, cases and what to do about them. Obviously, you know, in some cases, you know, perhaps people should know about, you know, what you may be limited to do with the law. Either way, that you only can get so much of a sentence. In other cases, people think, gosh, this has never happened before with this person. You shouldn't, you know, give them a record for life. And yet, I imagine, you know, that there's also a school of thought that record they're going to have for life, or the charges that will be on the record, all of that pretty much determined before you ever entered their life. You know, their actions prior to the arrest or prior to the incident determine what's going to happen, and a lot of that done before you in your office or even the judge enters the picture.
Sure. Every case file at court is somebody's life as the defendant, and they've got a family that's impacted by whatever this is, and, you know, perhaps employment, you know, even if they're losing their driver's license for a while. I mean, that, you know, so obviously far-reaching consequences of all this that we get up at court, but, you know, they've had lives before they come up there, and they will continue on after they pass through the system. And I mean, sometimes it's a one-off, and sometimes it looks like, oh, this may be a much bigger issue than anybody ever realized before this, and we need to take a closer look at how can we best help put all these people, I guess, in a better situation. You know, I mean, some cases the person needs a conviction. Some cases they need it dismissed. And there's every degree in between those two extremes. And, you know, every case is dependent on its facts and circumstances. It's the only way I can say it. But often just reading these cases, like, you just know as you're looking through them, you know. I mean, if it's an OVI case, we'll say, and, you know, you look and the person is in their young 20s, and it's a third OVI in 3 years, you know, and you pull up, you know, just their public access to their social media, and they're out partying all the time. It's like they might have a different issue than, let's say, it's somebody who's in their mid-70s, clean driving record, and now they're 3 times over the legal limit for an OVI. You may ask yourself, why is that? They might have got, you know, flown under the radar all these years. They might have just, you know, got lucky, we'll say, but maybe there's something else going on in their life. You know, we've had multiple cases where it's like a self-coping mechanism for grief. At that age, it's often the loss of a spouse or even a child, or, you know, like, so in that case, that's different than our young man in his 20s, you know, who's out getting his third OVI here. You know, we'll say this lady here, like, we'll send her, you know, suggest, shall we say, because we can't force. We can incentivize, you know, in many ways, we'll say. And it's one like, look, if you know, because the court will often require like a mental health evaluation or whatever before you'll, you know, be released from jail, so they have some idea, you know, what might be going on here. But basically, like, if you follow your counseling recommendations here, like we will have some room. And sometimes that might be a dismissal. Many times it's an amendment to something that's more palatable for whatever, I guess, might be motivating that defendant. You know, if it's a, they might want their driver's license back sooner on something than, you know, we'll say than the maximum time or something like that. You know, maybe that's something that we can work out, because I mean, when I started as law director, I'd done defense work for 4 years, but I had a very seasoned police officer said to me that when you leave court, if you have done wrong, it should sting, even if just a little bit. And so if you, I mean, take it in a speeding ticket context, you know, I mean, if you're speeding and you're honest with yourself about it, and, you know, I mean, we get people go from one extreme to the other on whether they want to accept any and all or zero responsibility. And, you know, I mean, that's, you know, I guess if somebody has done wrong and it's clear that they have, and they come in accepting some degree of responsibility with it, like, even if, for example, in our 3 OVIs in 3 years guy here, like, assuming that it's a good prosecutable OVI, you know, I mean, I'm going to pretty well require him to plead his charge to that and not give him a reduction on that. But maybe he's also charged with, you know, like a headlight violation or something like that. You know, I could dismiss that as part of the deal. I could also say, if he takes his counseling seriously over the next, because we have 6 months pretty much to complete a misdemeanor case under the Ohio Supreme Court's reporting deadlines. And so 4 to 5 months is kind of a good, we'll say a benchmark to maybe set some short-term and starting some longer-term, you know, maybe treatment or counseling or whatever it might be for whatever the issue is. And it may be a, you know, for a 3rd and 10 OVI, there's mandatory minimum jail amount of days to serve, you know, and so it might be a, well, you know, you might be able to earn your way to more of a minimal recommendation of the actual days to serve, with many more suspended, because we just want, you know, we want to help you, we want you to not break the law, and we're going to try to figure out the best way.
And have to keep the public safe. That's the other thing.
Yes.
We all probably agree. We're hesitant to have this person on the road again for that reason alone, right? Just to kind of throw that one out there. And also the part of your job that, you know, for some people, you've just got to explain to them, you've got to be held accountable for your actions. We all do, right?
Yes, I always try to take that into consideration with everything, you know. I mean, if somebody, again, every case is different, you know, and I've had people that say, it wasn't me, I wasn't there, it didn't happen like that, you know, and they have been correct. You know, I mean,
Been cases, yeah.
But by and large, I mean, even if the person even if they aren't guilty of a theft, perhaps they are guilty of the lesser included, like an unauthorized use of property or something like that, you know. Or if they're not engaging in assault, maybe it is the lesser included of disorderly conduct. And I guess in one of those scenarios, I view it differently. If you come in and acknowledge, you know, I don't think I had somebody come in one time who said, well, I was being disorderly, and the officer told me to stop, and they said that they stopped yelling, but they were so intoxicated that they vomited. And that was the reason, according to this defendant, that they were charged with persistent disorderly. Now, the video showed there was a little more to it than that, but I talked to the officer, and they didn't care that I reduced it to the minor misdemeanor here.
Sure.
They were just taking care of an issue that night.
That time.
Yeah,
Right.
and the defendant was very happy to accept that plea, and I was happy to offer it. It worked out, and we haven't seen him back. That was 2012.
I am glad you came here. I thank you for your time. I'll remind people too, we'll have this online momentarily at WCSMradio.com. It repeats at 1:30. If you have questions of George, his address is 1060 West Anderson Street. I'm kidding.
Chicago, Illinois.
We can't do the show without a Blues Brothers.
No, and I live in Celina, so don't be,
Yes.
I live in Celina.
Don't look for the ivy.
I have to for my law director job.
All right.
And I love it. It's my hometown.
And coming up, we'll take a look at the radar. Weather Watch forecast brought to you by Technical Roofing.